Truly, love is in the air, and everyone loves a love story. So with Mother's Day approaching soon, a story about terms of endearment might be more endearing than one of a mommy dearest. But in October 1973, the story that Justice Blackmun told was that of Jane Roe, a single woman who was residing in Dallas County, Texas, who had instituted a federal action in March 1970 against the district attorney of the county. She sought a declaratory judgment that the Texas criminal abortion statutes were unconstitutional on their face, and an injunction restraining the defendant from enforcing this statute. Roe, as the court explained, alleged that she was unmarried and pregnant, that she wished to terminate her pregnancy by an abortion performed by a competent, licensed physician under safe clinical conditions, that she was unable to get a legal abortion in Texas because her life did not appear to be threatened by the continuation of her pregnancy, and that she could not afford to travel to another jurisdiction in order to secure a legal abortion under safe conditions. She claimed that the Texas statutes were unconstitutionally vague and that they abridged her right of personal privacy, protected by the 1st, 4th, 5th, 9th, and 14th Amendments to the Constitution, and by an amendment to her complaint. Roe purported to sue on behalf of herself and all other women similarly situated, seeking to help others. So, for the moment, let's try to imagine these events as they may have occurred, and not from the perspective of a casual observer, but rather thinking like a lawyer, as attorneys are supposed to do. Imagine yourself now as a dashing young attorney in Dallas, on the day that a young woman in the family way has come into your respectable downtown practice with a story about a personal injury, and claiming that she had been injured and wanted to obtain legal relief in court. In March 1970, most clients who walk into an attorney's office are not familiar with the law, are probably not familiar with injunctions, and more likely than not wholly familiar with a facial and as-applied challenge to statutes brought in action seeking declaratory judgment that a law is unconstitutional. Those are the thoughts of attorneys, not people walking in off the street. And if you wish to help this woman, what would be your first thought, especially knowing that litigation sometimes takes a little time, even if not realizing that this particular litigation would take over 3 years, making it any injunctive relief to stop the state from outlawing an abortion moot as law. You can't stop a pregnancy that has already happened. Although the litigation used the fictitious name of Jane Roe, the true name of the plaintiff was Norma McCormick, who was 22 years old at the time that the litigation first began, who had already given up 2 babies for adoption and decided she didn't want to have a third, and who later became a pro-life advocate after becoming a born-again Christian before her death in 2017. On June 2nd, 1970, just 3 months later, she gave birth to Shelley Lynn Thornton, who was adopted by other parents and who had learned from the tabloids, the National Enquirer, on her 19th birthday that she was the topic of the landmark litigation Roe v. Wade. And so it is clear that by this she presents herself at your respectable attorney's office. She is already at least 6 months pregnant, 26 weeks in gestational stage, to speak like a doctor, with only 10 more weeks to go, and probably noticeably so. And so, by the time the litigation reaches June with no injunctions granted, the situation for your young client had become overcome by events. But rather than abandoning the case, you decide to amend the complaint to read that the suit is brought on behalf of your single and poor woman client, as well as all other women similarly situated. Outstanding citizen in defense of rights. Why not seek a monetary reward for your client who is poor and perhaps in need of money? The most that a litigant can obtain from a suit claiming a violation of any civil right under Section 1983, however, is reasonable attorney's fees to ensure that at least the attorney gets paid. But only for those fees that are deemed to have been reasonable, meaning that this is not a rainmaker case for the firm, and probably taken on with an expectation of a considerable net loss. In a standard personal injury claim, an attorney would pursue a litigation against a culpable party, someone hopefully with deep pockets, like a manufacturer in products liability case. And in this case, that might include a contraceptive provider or a prophylactic manufacturer. But what would be the problem there for an attorney thinking like a lawyer? You can't save the world if you can't pay the rent. There are quite a few problems that a law student might be expected to identify in an issue-spotting fact pattern on a first-year law school exam. And the first one arising under the law of contracts regarding any express or implied warranties from the prophylactic manufacturers and contraceptive providers is probably under the law of disclaimer and waiver. Manufacturers inform all consumers that oral contraceptives, most commonly called the pill, suffer breakthrough infections about 2.1 to 6.7% of the time, with obesity often associated with higher risks. Condoms and diaphragms between 2 and 15%, depending upon proper use, and a copper intrauterine device between 0.1 and 1% of the time, if placed within 120 hours or 5 days, and do not guarantee 100% perfection. Under the law, this commonly takes the form of a general disclaimer or waiver or indemnity clause, granting at least a limited immunity from liability in civil action for the manufacturers, distributors, and others in an intercourse of commerce. But even if an attorney could somehow develop a case to establish the presence of a patent or latent defect, any first-year law student could tell you that that would be a losing case. Why? Your client had an unplanned pregnancy admitted, had assumed a certain level of risk upon usage of the manufacturer's product, like riding a motorcycle without a helmet. And the common law rule is that there is no remedy at law for a plaintiff who had been contributory negligent. And generally, to satisfy minimal standing, a plaintiff must suffer an actual and direct injury that can be remedied by a court with an affirmative defense of contributory negligence would easily defeat. So if you can't sue the manufacturer, then why not sue the government? As the plaintiff's attorney in Roe v. Wade decided to do, recognizing that their client's life did not appear to be threatened by the continuation of her pregnancy, as required under the laws of Texas for an abortion, and that she could not afford to travel to another jurisdiction in order to secure a legal abortion under safe conditions. Why would you take that case, recognizing that you were going to suffer a loss even if you win, because you'll only be awarded reasonable attorney's fees to do the right thing? Well, to present a prima facie case, as lawyers seek to do for injunctive relief, a plaintiff must establish that they will, more likely than not, prevail on the merits of the case, that there will be no greater prejudice to the defendant in a balance of equities by granting the injunction, that granting injunctive relief would be in the public interest, and that an irreparable harm had been incurred by the plaintiff. An irreparable harm. And generally, when a claim involves a substantive civil right, the courts have determined that its derogation, absent other compelling interests, would constitute an irreparable harm as a matter of law. So, the plaintiff's attorney in Roe v. Wade simply decided to bring a claim that their client had a substantive right in personal privacy, they called it, that had been abridged by the Texas law, essentially claiming a dubious claim to a personal right to assume a risk without consequences and engage in conduct in which she had been contributory negligent, for which generally there is no remedy in law. The case should never have gotten started. Consider the case of Wright v. Atlantic Coastline Railway Company, which had been decided by the Virginia Supreme Court of Appeals in 1910, a case that had been brought to recover damages for injuries alleged to have been suffered in consequence of the negligence of the defendant railroad company. Describing the facts, the court explained that on the day of the accident, the plaintiff, a young, strong, active woman and her mother, went to a flag station on the line of the defendant's railway to take passage to Suffolk, Virginia, another station on the line of the same railway. That at the flag station, no regular resident agent was employed, and those desiring to board trains being invited were required to stand on or near the track and wave some object across the track as a signal to the engineer to stop the train. That the station was reached within 1 hour before the arrival of the expected train, and while her mother was some distance away and on the opposite side of the track from the station, the plaintiff saw a train coming, which she took to be the passenger train she expected to take, but which turned out afterwards to be a fast freight train. That she saw this train when it was 500 yards off, and when it could have been easily stopped before reaching the station, and that as soon as she saw it, she stepped upon the track and commenced in the usual and customary way, signaling to the defendant's employees to stop the train by waving across the track a large bag or box, which was seen by those in charge of the train in ample time to stop before reaching the station. That while thus standing and signaling the train, she saw her mother walking along the public highway toward the railroad crossing, 20 yards east of the station. In the unobstructed view of the employees on the approaching train, and at such an angle that her mother's back was toward the engine, and that unless her mother stopped or turned aside, or unless the approaching engine was stopped or its speed slackened, her mother would reach the track at the public crossing just in time to be struck and killed by the train. All of which was plainly seen by the defendant's servants, who carelessly and negligently failed even to sound the whistle for the public crossings as required by law. And that thereupon, in order to save her mother from the danger in which the defendant's negligence had placed her, and from the certain death then impending, she shouted to her mother to stop, which because of the noise and confusion of the train approaching, her mother could not hear. Or if she heard, did not hear. That at the same time the plaintiff persistently stood on the track in full and unobstructed view of the employees who were operating the train. And while there was ample time to stop or slacken the speed of the engine, the plaintiff, believing that the only way to save her mother was to keep herself in an obviously dangerous place, and thus stop the oncoming train, that under these circumstances the defendant's employees knew, or ought to have known, that she expected them to stop the train or to impede its speed, and that she would not get off the track until one or the other had been done, yet the defendant not regarding its duty, but grossly violating the same, wrongfully and negligently had failed and refused to stop its train or slacken its speed, or to indicate by short blasts of the whistle, as is the well-known custom, that the train would not stop, by reason of which negligence the engine struck and killed her mother, and that the plaintiff was either struck by the lifeless body of her mother being hurled with great violence against her, or the plaintiff not having gotten out of harm's way quite, was struck by the overhanging parts of the engine, thereby causing the injuries of which she then complained. And that court, listening to these facts, reiterated the common law rule that contributory negligence bars recovery in a courtroom, but went further to state an affirmative defense for the freight train company, emphasizing that the rule is believed to be universal. It is certainly firmly established in this jurisdiction that the engineer has the right, under such circumstances, to assume that the party is in the possession of his or her faculties and will retain his or her place of safety and not recklessly expose himself or herself to danger. You can't stop a train, and most reasonable people know this. Love may make one do crazy things, but there is no right recognized under the law to be reckless when standing in front of a train, nor entitlement to sexual pleasure without consequences under normal circumstances in the law. And in that case, the reviewing court found that the allegations show that the plaintiff deliberately stood upon the track in front of a train which she saw was rapidly approaching her, and made no effort to get out of its way. She deliberately refused to exercise even ordinary care to avoid injury to herself, which she could have easily done by stepping to just one side. And that reviewing court thereupon concluded that there can be no question that she was guilty of contributory negligence, unless, as contended, her act is to be excused upon the ground that she was injured while attempting to save a human life, which was, as alleged, placed in jeopardy by the defendant. However, as stated in Kimball v. Carey in 2010, The courts of Virginia have consistently held that while it is truly commendable to attempt to rescue a fellow human being, the rescuer cannot recover for injuries sustained during the rescue attempt if the rescuer had acted rashly or recklessly in disregard of his or her own safety. So, their body and their choice. So accordingly, a court of competent jurisdiction may conclude that a claim of right to an alleged right to privacy, much less entitlement to sexual pleasure, might subordinate any privilege granted under the rescue doctrine would work quite an absurd result. In Zolman v. Moore, decided by the Virginia Supreme Court of Appeals in 1872, almost 100 years before Roe v. Wade, the court stated, "The case is a very hard one, I am free to admit. Hard that this poor widow should be stripped in her old age of the little estate derived from the bounty of her friends. But the struggle through which we have passed is a history of afflicting calamity, a vast maelstrom in which were engulfed the fortunes of countless human beings. It has been the misfortune of the present court to be compelled to apply the severe rules of law to many cases which might well excite the commiseration of the hardest of hearts. We are required, however, to act upon fixed principles. We have no power of superseding or modifying the law, or of enforcing the charities flowing from a natural equity and justice. It is better there should be individual instances of suffering and loss than that established principles should be violated, and chaos and confusion produced in the administration of justice. These views render it wholly unnecessary to consider the other questions so elaborately discussed by counsel. Thus, essentially, with the non-emotional calm of a scientist, like some have claimed in 1847, the American Medical Association had attempted to lobby for anti-abortion laws to create a monopoly for professional physicians to the injury of midwives who had also claimed an entitlement to participate in the business of terminating pregnancies. Under Roe v. Wade, the government became the indemnity insurer of the contraceptive and prophylactic manufacturers, while also recognizing a very dubious claim of a right to engage in wanton or reckless behavior without attendant assumption of risk that has generally precluded recovery for plaintiffs in court. Recovery denied to a woman trying to rescue her mother on a railroad track. Hard cases, attorneys say, make for bad law. But how does this conventional application of jurisprudence and principles affect the traditional objections like rape or incest or threatening the life of the woman? The law in equity generally seeks to compensate a victim for injuries incurred so as to make them whole again, and like in the classic case of Rylands v. Fletcher, known to most law students and decided in the Court of England in 1868, around the same time that the 14th Amendment had been adopted in the states, will hold the defendant liable for conditions that they had brought upon the land. And at least with regard to the cases of rape and incest, a court in equity would find a remedy in restitution, as any first-year law student could inform you and recite without ever getting to the discussions regarding what res or subject of the matter regarding the fetus might contribute to the case, and which even under property law might recognize an expectancy interest, which a plaintiff will have conceded by the simple act of seeking an abortion to terminate. which would reduce the list of potential claims brought in a court to only one, threatening the life of the mother, wherein any court might recognize a claim of right to self-defense as a choice for a loving mother to make. But, as in politics, in a courtroom where we stand is all too often where we sit, finding ourselves just a little bit more selfish than we like to admit. And at least a wise King Solomon had found a mother who would rather give away her baby whole than take its life to preserve just a half for herself. Whoa, it is that thing. So, as St. Augustine says, love and do anything you want. And we'll be right back after these messages, folks. Don't go away. This advertisement was authorized by Mike Webb.